and Dorothy for bringing me here, and all of you for being here. As you probably knew when you signed up to come tonight, that this is a presentation about copyright. So I like to say this is the eat the vegetables portion of your writing. So kudos to you for being here and educating yourself about this side of the business. Authors Alliance is a nonprofit organization. We're based in Berkeley, California, which is where I came from tonight. We have about 1,500 members, but we're a relatively young organization. We're about 4 years old. And we provide educational materials and advocacy for authors, largely around legal issues related to writing. And that's what I'm going to speak about tonight. So things like copyright, fair use, publication contracts. So I'm going to go through 4 topics tonight. This is way more than I could possibly go into comprehensively in the hour I've been given. So consider this an overview. Consider this a little bit, educating yourself a little bit about what you don't know, and maybe you can ask educated questions, get more information after this introduction. The 4 topics we're going to cover today, we're going to start with just copyright basics. What is copyright? And then we're going to move on to a little bit of information about publication contracts. Then we're going to talk about a term that some of you have probably heard about, fair use. And then we're going to end by talking about getting your rights back. A couple things you should note. I am a lawyer, but nothing that I say is legal advice, so I'm just imparting information. I'm not actually able to apply this information to your facts, but maybe I can point you in the right direction if you have questions. So copyright basics. Does anybody know the purpose of copyright? Protection, I heard. Protection is what copyright gives you. That's a good starting point. And the reason that you're given protection through copyright is that when our Constitution was enacted, the idea was that authors and inventors and other creators need incentives to create. And by giving them protection for a limited period of time, that means that there'll be some incentives for authors to create because they'll be able to have some time to reap the rewards of their writings. There is another side to the coin, which is that the Constitution explicitly states it must be for a limited period of time. So the flip side of the coin is that we have all this work being generated, these inventions being made, and we want to protect it only for a limited time because at some point it becomes a cultural good that we all build on, we use, we create on top of, we use the works of those that came before us. So the limited time is an important part of this. The limited time has expanded over the years. So when the Copyright Act, well, in 1790, so prior to the Copyright Act, copyright was only in the statute of Anne 14 years. It's expanded over time, so copyright is for an individual author. Your work is protected for the life of the author, plus 70 years beyond that. So it's extended drastically over time. How do you get copyright protection? It's automatic now. This didn't used to be the case. So as I said, that it's been expanded over time. Another thing that's happened is that there are no longer what's called formalities, so requirements in order to get copyright. It used to be, and there's some myths that remain from this, that you used to have to put a C with a circle around it, so notice, in order to get copyright. That's no longer the case. Your protection is automatic, no matter whether you register it, no matter whether you mark it as copyright. From the moment you put pen to paper, that work is protected. But don't hear just that without hearing the second half of what I'm going to say. You can still register your work with the Copyright Office, and there's really important benefits to doing so. One of the benefits is you can't sue somebody for infringing on your copyright until it is registered. You're also eligible if you have timely registration. So if you register within 3 months of publication or before the infringement happens, to get extra damages, so extra money in the event of a lawsuit. So that's well and good if you care about infringement of your works. Another reason I think it's really important is copyright registration establishes a public record of ownership. So in the past, when formalities were required, there was somewhere to look if you found something and you wanted to ask for permission to use it. Now, because of the absence of formalities, that isn't always the case, so we have a lot of works that are called orphan works. We don't know who owns them, we don't know who to ask how to use them, whether it's okay to use them, whether we can license that. So you can imagine photographs often fall into this category. You might want to incorporate a photograph into your work. You would even pay for a license, but you can't find the owner. So if you register your works with the Copyright Office, that is a place that people can look if they find your work and ask you for permission to use it if you still own the copyright. There's a lot more information on our website about the benefits of registration and actually how to go about registering your work. You have a link in your handout, and it should be fairly easy to find on the website on our resources page. So what does copyright give you? We heard protection. That's true. Copyright gives you the exclusive owner of the copyright, which is originally the author for a work that is authored by an individual, not in their employment. It gives you the exclusive right to do a number of things with your work. It gives you the right to reproduce your work, to distribute your work, to prepare derivative works. So, for example, movies based on your book, that is the right of the copyright owner. To publicly perform the work, like a play, to display the work, and all of these rights initially vest with the author. What happens is, often when you're asked to sign a publishing agreement, you're asked to transfer some or all of those rights to your publisher. And that's something you should think about. We'll talk a little bit more about that when we talk about a publication agreement. To some extent, you have to grant your publisher permission, at least to do these things. If you don't give your publisher permission to make copies of your work and to distribute it, they can't do anything with your work. But you should know that that's a really powerful right that initially vests with the author. You can hand those rights away all together as one big bundle, or you can hand them in separate parts. So it is perfectly reasonable and done to hold back the right, for example, to make derivative works in case you want to, say, make a movie adaptation or a children's book based on your work. But that's all part of the negotiation with your publisher. So the flip side of copyright is the public domain, and this harkens back to what I just said about Congress wanted copyright to be for a limited time, so that after things are done with the term of copyright protection, they are able to be used and built upon by other people. So one way that works enter the public domain is because their copyright has expired. Right now, the only thing that I can say for certain is that works first published in the United States before 1923 are in the public domain. They're free for anybody to use. There's a period of time between 1923 and 1977 that works might be available to be used, depending on whether they followed formalities that were in place during that time. The other things that are in the public domain are materials that just can't be copyrighted to start with. Some of these are quite obvious. For example, facts. Facts can't be copyrighted. No matter how hard you worked to uncover a fact, you can't have exclusive ownership over that. Okay, facts are not copyrightable. So if I do a lot of research, I uncover a lot of information, say for example about battles in a war and things that happened factually, what date this key battle happened, who perished during that battle. Those particular facts can't be copyrighted. The way in which they're presented can be, so the narrative around how you're telling the story can be copyrighted, but the factual elements of it are not. The other way that this comes through is plot structures. So you cannot copyright a basic plot structure. So this is why you see lots of stories out there where, boy meets girl, they fall in love, the boy loses the girl, and then he fights and wins her back again. That general kind of plot structure can't be copyrighted. The essential details in how you tell that story and your narrative around that can be copyrighted, but you can't stop somebody from using that same sort of story. There's other things that are not copyrightable: names, titles, short phrases. Some of those can be trademarked, so Just Do It, for example, it can be a trademark, but it's not copyrightable in and of itself, neither are titles. The other way that works can enter the public domain is you can dedicate your works to the public domain. So this might seem counterintuitive. I just told you all the rights that copyright gives you, but sometimes that might not be appropriate for your work. So I write a lot, for example, blog posts on my Authors Alliance website, and I license those all under a Creative Commons license because it's to my benefit to have those spread, passed around. It's good marketing material. I issue those under a Creative Commons license called CC BY, which means the BY means it has to be attributed. So you can see how this could be beneficial for certain types of works. Creative Commons licenses are just a standardized set of licenses issued by a nonprofit organization called Creative Commons, and they're free for anyone to use. They're a universal way of marking a work that indicates how the public is allowed to use and interact with your work. Otherwise, the default is that it's protected by copyright and no one can use it. This is popular in particularly the academic world, and in fact it's becoming increasingly required by grant funders, universities. Faculties are passing policies that say that their works have to be licensed openly. The idea is, for some universities, the material has already been paid for by the state or through tuition or by the grant funder, and that the idea is that this knowledge should be spread and open and passed along and built upon. We also do have members that use Creative Commons licenses very creatively for their works. So maybe they have a fiction work and they want to spread the word and get it out there. They might issue one chapter under a Creative Commons license that allows people to pass it, share it, email it, print it, hand it to their friends without risk of copyright violation, and then have a link to the full thing, which may or may not be Creative Commons licensed. This might sound surprising, but we also have members that license their books under Creative Commons licenses when they're digitally available, and then they still sell print copies, and it works for some people. And this is how we license all of the books that we create as Authors Alliance. They're freely available on our website as PDF downloads, but we sell hard copies to cover our costs. This one that I'm holding up now is the one to Understanding Open Access, which is what I'm talking about now, using Creative Commons licenses to tell other people how they're allowed to use your work. There's different variations. I told you one of them is to require attribution. That's standard on all their licenses. You can also tell people that they can use it, but only if they use it non-commercially, only if they don't make derivative works based on it. And another requirement could be that they also share anything that they use, they create based on your work. So there's all different variations of that. This open access guide is where to look if you're interested in more information about licensing your works in that way.